I'd have to break into my house. Time for Thinking Real Estate. Laura Dwyer Schlechte, Bill Schlechte. Laura from Thinking Real Estate. Bill from
Just thinking.
Schlechte, attorney at law.
Schlechte. I'm going to correct you.
Schlechte.
There.
Well, that's,
You're close. Hey,
Yeah,
everybody
everyone
butchers their
knows who
name
you're
anyway.
talking
It's no
about,
big
right?
deal, okay?
After how many years of doing this show? Are we in our third year?
Going on.
oh, it seems like it's
Seems
been a lot
like
of-
forever.
Seems like,
doesn't it?
yeah, it seems
Yeah.
like 10 years, right?
Yeah.
So, what are we talking about?
We're going to talk about riparian rights today because I had a
Unless
call
Craig had
from
any
somebody
questions
regarding
he
it.
wanted.
No.
No, we're not talking city politics. That's off the
Well,
table.
who said anything about that, Bill?
You were gonna. I know.
No,
I know where
no,
the
no, no.
conversation was headed.
I've had politics up to
I'll bet.
my eyebrows
I'll
this
bet.
week.
I'll
yeah.
bet. I'll bet.
Got it.
So no,
I've been out there.
I deal with riparian rights a lot. I'm about to start a lawsuit out on the west side of the state.
So what
I
are
got a call.
riparian rights?
The rights, water rights. You know, on we think of riparian rights on inland bodies of water, littoral, L-I-T-T-O-R-A-L, with respect to large bodies of water, the ocean. But we call them riparian rights strictly here in Michigan, whether it's the Great Lakes or inland lakes. And I just, I got a call that's fairly typical from an owner on a small lake here in Jackson County, and the neighbor is contesting where they're putting their dock and where they're parking their pontoon boat, all that sort
Well,
of
that
stuff.
happens all the time here.
Thank
Right.
goodness, I love those disputes, okay? That people fighting over their boundary lines and what they can do and what they
So how do
can't.
you figure them out?
We have a relatively
You flip a
short
coin, or-
program. No.
Okay.
I mean, there are a variety of rules that apply to lakes and streams, and so I had a conversation with the person who called me about what those rights were to see whether or not the parties could actually come to an accommodation. But if they can't come to an accommodation, then we'll have to start going down the.
Now, who creates these rules? Is it the township?
No, this is all pretty much derived from the common law, from the English common law.
Okay.
And then
Wow.
adopted by the courts here in the state of Michigan. There are a number of cases, Hilt v. Weber, just tons of them. Glass v. Geckel was the most recent one involving the Great Lakes. Just a series of cases since the 1800s that have developed the riparian rights law in Michigan. And then there are statutes as well.
Okay. Townships, counties, lake associations, can they override riparian?
Yes and no. Let me give you a good example. In 2012, we adopted, I think it's Act 43 or 53, I can't remember, to deal with road ends in subdivisions. You could go out to Clark Lake or any one of the lakes here, these subdivisions developed in the 20s and 30s and 40s. And they all provided for the streets, or the roads within the subdivision. And then on the plat itself, there was simply a notation that said roads dedicated to the use of the public. And then what happened was the roads were developed, they were taken over by the municipalities, but the road ends that ended at the lake themselves, those were never developed. And so what would happen is backlot owners in the subdivision would come and use the road ends, might be 40 feet wide, 66 feet wide, would use the road ends to put docks and put their boats and all that sort of stuff. Or the adjoining property owners to the road end would start encroaching. They'd put fences and shrubbery and things like that. And so to address road ends throughout the state, the state legislature adopted a statute that said jurisdiction over those road ends, it devolves upon or is now in the municipality that has control over the roads. So that now the municipality, to the extent that there is nothing in the plat or nothing in the deed granting the rights to the lake, the municipality has control over
So
the
that would
road
be
ends.
the Jackson County Road Commission.
In most circumstances, it's going to be the township. In some circumstances, it will be the county road commission. But there was a case out on, I'm trying to remember if it was Clark Lake or Round Lake. It was about a year and a half, 2 years ago. We went through that, and the county said it's the township's authority,
Clark.
and the township
Pretty sure
said
that's
it was the
Clark
county.
Lake.
They ultimately ended up, what had happened was a backlot owner in a subdivision had filed a petition with the township to put in a dock, and the township refused to
Yeah, I think that was
allow.
out in Hanover.
Was it? I can't remember exactly where it was.
Round
But
Lake?
He might have been. It was either Round or Clark. I can't remember.
I think it was Clark,
I think it was.
because Clark's the one that's more apt to have people using the road ends, not Round Lake.
Yeah, it might have been. But at any rate, the statute had just been adopted when this crossed my desk. But it was denied, and the statute says that what the township can do is, so long as there's no prohibition in the plat or no prohibition in the deed granting the rights to the road end, the township or the municipality has the right to allow temporary or seasonal docks, and you have to apply to the municipality, and the purpose is so you don't end up with all these backlot owners and even non-owners in the subdivision who would come down and put docks in and hoists, et cetera. So
Can I use that as a lake access though? So I have a house down the road it's a dirt road, probably is the road end, more than likely. And I have a house on the dirt road. Can I use that as my lake access, and then can I claim that in my title?
it would be up to
My
the
marketing?
it would be up to the municipality, and
Because we see that a lot,
do you?
especially at a Clark Lake. There'll be a house down the road, the realtor will say lake access, lake access.
Yeah, where the plat says dedicated
Well, isn't that
to
lake
the
access
public.
for anybody?
Well,
Well,
so
no,
we could have lake access.
That was one of the problems. That was one of the problems, whether or not it was lake access for absolutely any member of the public. And so the statute was adopted to try and address that, to give the municipality the ability to regulate who could actually get access and how that access was to happen. But the township is doing it on behalf of the entire public within that township, not just the lot owners within the subdivision. So,
So any public lake, any lake that has public access, I basically
If it's
could market our house on Michigan Avenue as lake access.
no, you cannot, no.
Are you taking calls?
Sure.
Good morning.
Hey, good morning. Good morning. Talking about that at Clark Lake, we have a situation where someone's building a house next to a road end, and we always have put our dock there and our rest there, and they called it a road end. So the last 2 years we did not put our dock in, and then we found out that there's a 45-foot strip, and the road commission's only claiming 33 feet of it. So right now, we're trying to say we got 12 feet to use as our path to get on the lake. Do we have a shot to keep our dock there next year there, Bill?
Probably not, because whether it's 33 or you said 45 foot,
Yeah, it's a 45-foot, that's the way the plot is, 45 feet. But the road commission, we got that written, where they're only claiming they want 33 feet of it.
you'd have to go back, you'd have to look at, this is a plat and this is a subdivision?
Correct,
Yeah, you gotta first go look at the plat, see what the plat says with respect to the entire 45 feet. If the 45 feet shows up as a road end, that falls within the jurisdiction of, as I said before, it's either gonna be the township or the county, depending upon which entity has jurisdiction. If the county's claiming 33 and there's still 12 feet there, you'd have to look to see again what the plat says, and then if the plat doesn't provide for anything other than dedicated to the use of the public, you'd probably end up going to the township. The difficulty with using, whether it's 45 feet, 33 feet, or 12 feet, is you have so many backlot owners who would claim the right to use that little strip, hence the need for the statute to regulate the use of it. So even though you might have been using it in the past, that statute's going to preempt whatever use has been happening. And so are you getting pushback from people with respect to putting in the dock, or are you going to try and...
Well, there's a person building a new house, and they only have 20 feet of lake right, but they're trying to basically steal, that other 12 feet. They're trying to, claim it as theirs.
Well, they don't have any greater rights than any other member of the public, again, assuming that the plat says it's dedicated
Couldn't
to
you
the
go
use
to
of the public.
a title company and have a title search done on it, and to start there?
Yeah, but I'm not sure what good that will do. If you know from looking at the plat that it's 45 feet, the county says we want 33 feet, we know where the 12 feet is. We know that it's part of the plat, we know that the county or the township, whoever has the jurisdiction over it, so I don't know that a title search does any good.
It might not, wouldn't it possibly show that maybe it's owned by somebody in the backlots?
No, we're assuming the plat shows that it's dedicated to the use of the public. Okay. So, but the adjoining property owner has no greater rights to it than you do or any other member of the any other lot owner in the subdivision or the member of the public if the roads are dedicated to the use of the public. So yeah, the answer to your question is you may have been putting it there for years, but that did not give you any perpetual right to continue putting it
So
there.
Bill, if you were him, what would your next step be?
Probably, well,
But we already put a dock in. And we
yeah,
already-
I was gonna say, what I'd probably do is I'd continue putting it in
Yeah.
until somebody objected, and then I'd deal with the issue at that point, because if you went to the municipality and you, either the county or the township, and you filed an application to put in a seasonal dock, my bet is you get turned down under the statute because you're one of innumerable number of people who might wanna put a dock at that 12-foot or that 45-foot strip.
And that's what we do. There's 4 of us that would like to reuse it again. Because
Yeah.
we always have used it, and now we're shut down.
Yeah, and you know, we start talking about adverse possession and things like that, but you cannot adversely possess property which is owned by or controlled by a municipality. That decision was rendered sometime in the late 1980s, so that's not going to work for you. I suspect you're under whatever rights are granted in the plat, which don't include you. And then second of all, if it is a road end, which is governed now under the new statute, you gotta go to the municipality. But, you know, sometimes it's, if nobody objects, it's like no harm, no foul. You continue to do it until somebody objects.
Alrighty. Well, thanks for your
Thanks for the call.
information.
Appreciate it.
You bet.
So I have a property that I'm working on where it's on a river. And I was recently told that the legal description of the neighboring property is on the boundary of the river and actually circles this house.
Well, that's an interesting legal description.
Right.
Okay. First of all, if my legal description says it runs to the water's edge, I own to the center of that body of water, as long as it's not the Great Lakes.
Right.
On an inland body of water, I own to the center of it. Now, you'd have to go back and you'd have to look at the original grants of the property owner, not the one that you claim is
Could it
circling.
possibly could be just an error from the beginning? Why would anybody do a legal description that circles? I mean, if they did that, that would be landlocking a piece of property also.
Yeah, I don't know the answer to that. You haven't given me enough facts upon which I can render an opinion. I just don't know what the circumstance is. Again, I'm giving you the general rule that I own to the center of the body
Right.
of water. Now, the call I got earlier this week, the dispute was over where is the bottom land that each property owner owns. And so many people who own property on a lake, for example, Round Lake or Clark Lake, they think that, okay, my boundary lines go from this point up on the road and they go down to the water's edge, and I simply extend those boundary lines out into the lake, and that tells me what my bottom land is. That's absolutely wrong. There are 3 methods for determining bottom land in Michigan. The most prevalent one is where you draw a median line of the lake, the center line of the lake, and then you draw lines which are perpendicular to the median line back to the boundary lines, so that the bottom land you own are not simply extensions of your upland boundary lines. They actually could be skewed one direction or the other. And then the other thing is that, okay, you have a right to put a dock, seasonal dock, on your bottom land, but you can't put it right on the edge of your bottom land so that you now moor your pontoon boat or other boat over somebody else's bottom land. You know, one of the issues we'll confront in this particular case is they have kept the boat over the bottom land of the adjoining neighbor, or may have for a period in excess of 15 years, and adverse possession does apply in that circumstance. So, I mean,
Well, our
they're whole-
property at Skiff Lake, the legal description goes out into the water, but it's not to the center of the body.
That's irrelevant. The fact that when it was platted, it's platted showing dimensions which are other than to the center of the lake is irrelevant. The land we own on Skiff Lake, for all intents and purposes, we own to the median, to the center of the lake. That's a little bit different case because you got 2 islands in that lake as well. So you now have some issues with respect to where is the median line, how you determine it. I've actually been involved in, I want to say 4 cases over the years in which we actually had surveys done by licensed surveyors to come out and determine where the median line or the center of the lake was in order to be able to determine the bottom land boundaries.
And then typically I see like at Lake Columbia, the association actually owns the water's edge.
Yeah, I mean, that, when Lake Columbia was formed, and there's another lake.
And Somerset?
Well, no, this is, I'm trying to think of the name of the lake up near Brighton.
Oh.
Where when that was developed, the developer actually created a strip of land 3 feet in width all around the lake. And the lake and the 3-foot strip are owned by the association. And there are no riparian owners. Nobody owns to the water's edge. And in order to be able to get lake access, you must be a member in good standing of the association so that you may cross the 3-foot strip around the lake. That's a completely different circumstance, and you've got a single riparian owner in that, which is the association.
So this caller really there was no problem until the guy started building.
This is one of those things where people exercise rights that they do not legally possess, but they do it, and unless and until somebody objects, who cares?
It's easier to ask forgiveness than permission.
Absolutely. Always easier to ask forgiveness than it is to beg forgiveness than it is to ask permission.
Sometimes you just have to ask. You don't have to beg.
No, usually you have to beg forgiveness. So, but when we talk about riparian rights, I mean, this is a subject that I could discuss for
Hours.
Yeah, I mean, it's very complex in Michigan. It is evolving. I mean, the case of Glass versus Geckel, which was about 6 or 7 years ago, established a right in Michigan and a principle in Michigan that has just been lying there. No court has resolved it for 200 years, 150 years. So things are still developing, and it's very interesting stuff.
I have a question. Is there a topic that you can't talk for hours on?
Well, riparian rights is one that you can go for a long, long period of time. But no,
Very few.
there are nuances to just about every real estate law subject that we could talk about.
Well, and if anybody has questions for future shows, they're more than welcome to shoot me an email with the thought process, and we'll see if we can address it. That's Laura, Laura, at 780-3800.com. So,
Isn't Laura thinkingrealestate.com easier to remember than a number?
well, they can do that one too. So many options. I do have a new listing. Speaking of water, this one is across the street from Michigan Center Lake. Crossed and down a little bit, but walkable to either Michigan Center Lake or Round Lake in Center area. It's 722 5th Street, cute house on the corner. It's really big. It's 1760 square feet, 3 bedrooms, 2 baths, obviously Michigan Center Schools. And it is listed for $94,900, move-in ready, clean, and ready to sell. So call me to see it, 780-3800.
Do you have an open house or not yet?
No,
No.
it's my birthday this weekend.
Happy birthday.
Thank you.
29 again, she is. Right?
39 again.
No, 29. She's 29.
Okay.
Yeah.
Well, maybe I don't like 39 yet, so he's going for the lower number. I don't know.
Well, happy birthday.
Well, thanks.
Oh, I just said that, didn't I?
Yeah, you did.
I will see you next week. Good to see you, Bill.
Nice to see you.
Jackson Music.